Beginning with State of Ohio versus Joe Bolognue, case number 29-286. We have read the briefs and are prepared to proceed. If you are, just a reminder that we do videotape the arguments, so if you can stay near that podium and keep your voice up, that would be helpful as well. On this case, I should also say the state has waived its oral argument, so you will have 15 minutes to present your argument.
Thank you, Your Honor.
Sure.
Good morning. May it please the court, Greg Matthews on behalf of Joseph Bolognue. It's my privilege to stand up here on his behalf today. Your Honors, you're aware that there are two assignments of error that are presented before this court. The first is that the trial court erred in its interpretation of law when it found that the assault, misdemeanor of the first degree, was an offense of violence under 2953.31. And the second assignment of error, which the judge has already pointed out, has been conceded to by the prosecutors, that the trial court erred when it denied the application of Mr. Bolognue without first conducting a hearing. I would just, at the initial outset here, point out the state has conceded this is error, just reversible error, and should be remanded back to the trial court, and argues that as a result, our first assignment of error is now moot. If the court should consider our first assignment of error as potentially moot, I would submit today that this appeal is more significant than solely the issue of failure to conduct a hearing. And it's important for this court to review and decide plaintiff's first assignment of an error as an exception to mootness, because there are questions raised that pertain to great public or general interest. As this court may be aware, I believe this is a case of first impression. When I searched, I could not find other appeals yet in the Court of Appeals on this issue. This statute, or this case grows, has been amended a number of times since 2012 to expand the statute by our legislature. The last minute became effective on October 29th, 2018, just about 9 months ago. Appellant's application for sealing was filed days after the effective date of that statute on November 9th, 2018. And appellant's eligibility is dependent upon the interpretation of that new provision of the statute in 2953.31A1A. The trial court, in its decision, specifically cited 2953A1A and applied its interpretation of the law to the statute in denying the appellant's sealing of record. The trial court's decision appears to contradict the plain language of the statute. And if the trial court is wrong, its decision can set a wrong precedent and create confusion for lower courts, and will ultimately, I would think, be appealed back to this court or other courts on this very issue.
So why wouldn't we remand and let the court make this decision at the new hearing?
Well, I believe the trial court has made her decision very clear in her decision. Like I mentioned, she cited this very specific statute.
Of course, at the hearing, she may come up with a different conclusion.
Well, I mean, her entry speaks for itself. She says, if the applicant has been convicted of an offense of violence and a felony sex offense, the applicable statutory authority is not 2953.31A1A, but rather 2953A1B. And she goes on to say, you know, an M1 assault is a crime of violence for purpose of this statute. So I think the trial court has manifestly made itself clear in its order, and even she issued a subsequent order when I filed a motion for reconsideration and asked for a hearing. She said that again. She cited 2953A1A and as not being applicable because that M1 assault precluded Mr. Bolognue from having his record sealed. So I think.
So are we then issuing an advisory opinion to the court on remand? This is how you should, or should we let the court apply the law as the lower court apply the law as it interprets and then let you appeal it?
Well, I think the issue of the legal question that's presented here in this case I think this court needs to provide some direction to the lower court. I think she's obviously stated her position and her reasoning, and I think it's important for this court, not only for this trial court, but other trial courts, where there have been no decisions in the case of first impression, to provide some direction for our lower courts. So I honestly believe this is a question of great public interest or general public interest.
Counsel, did you talk in your initial motion or your motion for reconsideration about a hearing?
Well, I did, yeah. I requested a hearing, cited the case law that's actually in our brief, and that it's been, regularly upheld that a hearing is required. And I'm not a big proponent that it has to be a oral hearing, but at least it should be a non-oral hearing, allowing parties to be notified of the hearing, to present briefs, and to have their day in court, in a sense. So we did raise that.
Well, the only reason I was asking is because the court does say that he's not eligible. So if you're not eligible, there's really no reason for a hearing, right?
Well, I disagree with that legal interpretation. She's applying the law, and I believe her interpretation is incorrect. And I believe
I
it's...
understand that, but my question is, let's just step back a second.
Okay.
If the law says you're not even eligible for an expungement, what's the point of a hearing?
Let me see if I understand your question. Are you saying that she lacked jurisdiction to have a hearing?
I'm not saying that she lacked jurisdiction. I'm saying I'm wondering, I'm asking you, could it be that maybe she thought there was no reason to have a hearing because he's not even an eligible offender?
Well, I believe 295332 says that in every case a hearing shall be set. And the parties are allowed to be present either in pleadings or in present to make arguments on behalf of their clients.
So you're suggesting that even if it's clearly something that is not eligible, it's an aggravated murder conviction in the past, that you're saying that even though you're not eligible, if you apply, you still have to have a hearing?
I think aggravated murder is a stretch, but this is an M1 assault. And our lower courts have regularly said that M1 assault is eligible offense under the expungement statute. And none of that has changed under the amendments. So what I'm saying is, there are certain preclusions, felony first degree, felony second degree, they are not eligible for expungement. Could those be handled summarily by an order? I suppose so. And I don't think you would have too much contest from attorneys or parties based upon that issue because it's so clear. But in this case, we're in an area where I think courts have established a particular offense as eligible in the past, and statutory language seems to clearly indicate that this type of case should definitely have a hearing.
Well, the reason why I'm asking these questions is I'm wondering if the court should not, maybe we should give some guidance to the court below, because if the court is thinking that this statute doesn't apply, that he's not eligible under the statute, and therefore did not have a hearing, it seems like there won't be much purpose of a hearing without making a determination as to whether he's an eligible offender.
I agree. If that's her conclusion up front, then she may be in that line of reasoning and just not requiring a hearing or not allowing for a hearing under something that she perceives as not eligible to begin with. So in that case, I believe some direction from this court would be essential. I mean, I can tell you from my own personal experience from my trial work, I'm also getting mixed decisions from courts. I'm finding that some courts are granting expungements when someone has multiple convictions under A1A, even though they have an assault conviction, a misdemeanor assault conviction. And this case, particularly, is an example of a differing opinion from a differing court. So,
but in those other cases, of course, there was a hearing that was held, and the court made the decision. So both sides had an opportunity to argue the law, which in this case you didn't have an opportunity to.
That's correct. Yes.
Did you argue the law in the briefs? your
I did.
motions?
I did both.
So it's
issues.
just, you didn't have the oral opportunity, and I'm sure you were more persuasive in person, but I'm just saying.
Maybe not. Yes, I outlined both the issue for the need for a hearing in 2953-32 and the statutory language and the case law, how assault charges are routinely determined by courts to be eligible for expungement. So, but you're correct. I mean, in the other hearings that I've had hearings, the judges have listened to our arguments and have granted those. So I believe while this case may be a first appeal on this issue, I think it's, like I said, critical for this court to provide some direction for our lower courts so that people who may be entitled to this relief under the statute are continued to be denied that relief. And I also firmly believe that, that if this case is remanded back simply on the issue of failure to hold a hearing without any direction to the lower court, I think we'll be back here. I think you'll see me again standing up here on behalf of my client. But that only adds additional cost and legal expense to Mr. Bolognue, to his effort to obtain justice or a final decision in this matter. And I would also say, in my experience in doing expungement work, many of these people who are seeking that relief aren't employed because of their record or are financially, not in a good position because of that record. So that particular issue may evade review in subsequent hearings just because people often are not in a position to go to the expense to the Court of Appeals. I believe the Supreme Court has held in State v. Bishop that even though a case may be moot, a court may hear the appeal where the case presents a constitutional issue or questions of great public or general interest, even though that issue may have become moot as far as particular parties in the action. The Supreme Court has held this in a number of cases and affirmed that kind of ruling in a number of cases as well. I believe in this case where there's been a wrongful or erroneous determination of question of the law, it should not be allowed to stand as a precedent in light of this legislature's clear intent to expand the statute. And the court may be well aware that their Senate or the House has passed another proposed change to the statute. Our legislature is trying to bring more people under the benefit and the beliefs that are permitted under 2953-31. As far as the issue on the assault, I think the statute itself is probably the greatest authority. 2953.31, the very first line says, as used in section 2953.31 to 2953.36, which is the section that the judge used to rely on to deny Mr. Bolognue. He said, these terms apply. And then if you go back to section 2953.36, it says that except as otherwise provided in some subsequent sections, 2953.31, 2953.35, do not apply to the following. So they outline some preclusions, but specifically under 2953.36 A3, the certain offenses of violence are lifted out from that preclusion as not being precluded. It's kind of a double negative statute, but what it says basically, it identifies certain offenses that are precluded, those being crimes of violence, felonies, and misdemeanors of the first degree of crime of violence. But it goes on to accept from the definition of crime of violence specific offenses. And assault, misdemeanor first degree, is listed as one of those offenses that are lifted out as an exception. So I believe the trial court didn't look at the whole statute. I think she looked at that first section, that new section that was amended in October of last year, and made a decision solely isolated based on that section without looking through the rest of the statute and how it ties in with 2953-36, specifically Section A3. So, I have 38 seconds. I appreciate your time. I'll be happy to answer any additional questions that you all may have.
Well, that's the beauty of the clock up there. You get to look up and know exactly what time you have left. Any questions, Judge Carr? Judge Schaefer? All right, thank you, Attorney Matthews, for appearing today and for the argument. We'll take the matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the court's decision on the day it's released. The opinions are also posted on the Supreme Court of Ohio's website, so you're free to check there as well. Thank you again for appearing.
Thank you.